Good afternoon and welcome to today's webinar. My name is Russell Ford, attorney owner of Ford Murray, a business immigration law firm. And today's webinar is going to be, today's webinar is entitled, You've Got Questions, We've Got Answers. We're going to try to answer our clients' most common and frequently asked immigration questions. So we're going to cover a smattering of topics. And hopefully we'll get to all of your questions, but if we don't, please feel free to email us directly and we will do our best to answer offline or in our next webinar where we attack even more of our clients' common immigration questions. So as I said, our agenda today is we're going to cover a potpourri of topics. We're going to run through the most commonly asked questions that we get on a daily, weekly, monthly basis from our clients, whether it be new clients, existing clients, whether it be large companies, small companies, individuals. We're going to try to cover that whole gambit of topics to make sure that you as a listener are getting access to what people are asking. Because if some of our clients are asking, then most of our clients are wanting that same information. And so that's what we're trying to achieve today, is to make sure that you all have access to that information and feel like you're getting some good information to digest, to help you understand some more of what you're getting when you go through the immigration process, and help you get access to some of our materials and some of our information. And as I said, if you have a question that you didn't email us beforehand, or you thought of during the presentation and weren't able to get to us during the presentation, send it to us afterwards and we'll answer you offline, as well as try to address it in our next webinar that goes through a similar subject line. So let's jump into the questions that are most appropriate to the current timeline. We're in for what immigration attorneys is known as cap season, and a lot of clients like to know, what is the cap, where does it come from, what does it do, all of that. So let's jump into those H-1B cap related questions and see if we can get through a good number of these and help you get comfortable with the cap itself. So first and foremost, what is the H-1B cap? The Immigration Service limits the numbers of new H-1Bs that are available on an annual basis, and that number is limited to 85,000, 65,000 for individuals that hold bachelor's degrees, and an additional 20,000 for individuals that have graduated from a U.S.-based institution of higher education and achieved a master's degree or higher. The cap itself has been arbitrarily set. Immigration, through a series of regulations, has come up with that number and has said this is the amount of new H-1Bs that are available in any given year. And because of that, employee or employers are limited to the number of individuals that they can sponsor, the number of individuals that they can obtain, and the number of new H-1Bs that they can bring in per year. And so knowing that there is a cap, it's good to know how the cap works. The cap itself is based on the government's fiscal year. So the government's year begins on October 1st and runs through September 30th. Under immigration rules, you can file an H-1B 6 months in advance of the start date. If the start date is October 1st, then that 6-month date is April 1st. So on April 1st is when all employers file their H-1B subject cap petitions. And these petitions generally are accepted by the immigration between April 1st and 5 business days, whether that's April 5th or April 7th in any given year. Which leads us to the next question. which is who does the H-1B cap impact? As I alluded to in my prior answer, H-1B cap cases are new H-1B petitions, meaning the individual being sponsored is someone who has never held H-1B status prior. So they're here in the U.S. as an F1 student, as a B visitor, a J1 international exchange student, an L, an F, an O, a TN, any other status, or they could be someone who's outside of the U.S. that you're trying to hire and bring into the U.S. If they have not held H-1B status within the last 6 years for any other employer, then they are subject to the cap, and that is who is impacted by this H-1B cap. So if you're trying to hire that employee, you know that you have a cap subject petition, and you know you're subject to this fiscal year timeline, which then leads clients to then ask, well, when should we start an H-1B cap petition? Because it has to be filed between April 1st and April, let's say, 5th, and because every H-1B carries with it this requirement that you obtain a labor condition application from the Department of Labor prior to filing your H-1B, in a normal situation, that labor condition application usually takes 7 days for the Department of Labor to certify. We found that when it gets close to cap season, the DOL is overburdened, the system itself gets overburdened, and those applications can actually take much longer than 7 days. And so ideally, the latest you want to start an application is March 15th. The real ideal for us is well before that. If you can start your petitions in February or early March, it allows us time to prepare the application, allows you time to gather the information, allows the employee time to gather the information, but most importantly, it gives the DOL plenty of time to process that LCA, and we can make sure we've got that labor condition application in place so that the rest of the H-1B can be filed for that April 1st deadline. Because there is a cap, because the number of new H-1Bs is limited, over the last several years, there's been a lottery. And clients have asked, well, what is the lottery? Why is there a lottery? Well, the essence of why is simple. The government gets more applications than available numbers. Now, in a real world situation, it should be first in, first accepted. If you get your applications in, then you should be first in line. But unfortunately, the way the USCIS system works, they have a mail room, which is run by a contractor. All of the mail gets dumped at the contractor. So they have no way of knowing whose were the first, whose were second, and so on. And so an onslaught of H-1B petitions comes in between April 1st and April 5th. April 5th, the USCIS sends out a notification that they're not accepting any more applications. The mailroom shuts down. They count all of the petitions that have been received. If they've got more than 85,000, then the lottery system is implemented and the cases are divvied up between those that are subject to the 20,000 master's cap and those that are subject to the 65,000 regular cap. And the government decides on a random lottery basis which cases are selected for those numbers. And if your case is not selected, then the case is rejected and returned. And which then leads to the next question, which is, what if my employee isn't selected? Well, oftentimes we like to go through those scenarios with employers beforehand so that they are prepared. But the essence of it is, if they're not selected for an H-1B cap, then we've got to look at, do they have other options for you to employ them? It may be that there aren't other options, and the only option is the employee upon the completion of whatever status they're currently in, has to go home. But oftentimes we're able to come up with solutions that allow you to at least maintain the employee on some level, whether that's the employee goes back to school as an F1 student and works for you part-time. Perhaps they're from Canada and you can obtain a TN, or perhaps they're extraordinary and you can obtain an O. We look at all of the other options and we decide, is there something that we can do to help you get that employee and keep that employee in the U.S.? If they're not selected, the client often wants to know, well, what happens to the fees that I've paid? On the plus side, the USCIS filing fees, because the case has been, in essence, rejected, are returned. And that's not a small amount of cash. I mean, the filing fees for an H-1B are $2,325 presently for most employers. If you were subject to what's called the dependent employer tax, you have to add another $4,500 to that. So if your case isn't selected, there's a substantial refund that's coming back to you in the way of U.S. government filing fees. So I guess there's some solace in knowing that at least that comes back to you if the employee isn't selected in the lottery. Although I think in most instances, employers would prefer to have the employee and not the cash. And then they always ask, again, what are the options to hire the candidate? Do we have any other means to keep this employee? And again, we look at those on the front end and we look at potential solutions, and sometimes there just isn't, but oftentimes there is. Oftentimes there's an opportunity for the student, again, to go back to school, do F1 curricular practical training, for the individual to look at other non-immigrant statuses that may help them. And for international employers, there's often an opportunity to place that employee in one of your locations outside of the U.S. And then look at other visa options down the line, perhaps like an L1 or something of that nature. So as an employer, you have to work within the confines of the lottery, but you also have to be willing to look at alternatives because, quite frankly, last year, with the cap of 85,000, the government received over 200,000 applications. Your chances of getting picked were less than 40% or less than 45%. And it, didn't leave a good taste in employers' mouths because they're invested in a candidate, they're invested in the process, and they have less than a 45% chance of that candidate being selected and being able to work for them. So you have to be willing to, again, work within the process and look at other options and be flexible in order to keep that best and brightest talent. We talked about that deadline. You have to file on April 1st. Well, what if your candidate is currently in school, but their graduation date isn't until May, and you want to sponsor them this year? Unless the individual will have finished all of the credits towards graduation prior to April 1st, that could pose a problem. And what I mean by that is, if the individual is graduating in May simply because the school only offers a graduation every May, but the person finished their classes in December, well, we can obtain documentation from the school that's saying, no, they've completed all of their work towards a degree, but our program only allows for a graduation in May, and therefore they get the diploma then, but they're essentially done. And that's usually acceptable by the USCIS, versus a candidate who is finishing up coursework and won't finish that coursework in May. Well, to file the petition on April 1st saying the person has a degree when they don't can result in the government coming back and saying, well, they weren't qualified for an H-1B, and even though you were selected for a number, the case is not going to be approved or going to work. And so you've got to look at the candidate and their graduation date, but you've also got to look at why that graduation date is in play. And if they are a U.S. student in an F1 program, you've got the benefit of they've got optional practical training, so you can employ them for a year without worry. But if they're coming from an institution outside of the U.S. and they're not going to finish until May, it can pose problems for you in trying to bring that student on board in an H-1B cap type situation. So you have to be cognizant of that. The other thing that comes up because of the lottery is you have individuals who will ask, can I submit more than one petition for an employee? I want to make sure that this person, we really like this person. We want to make sure they get selected. So we want to submit 5 H-1Bs, all for the same person, all for the same position, in the hopes that one of them gets picked. You can't do that, unfortunately. The government has come out and said that is not how the system works. One petition per employee. That being said, you might have an individual who fits multiple roles. Maybe they could be, the IT director, a software engineer, or chief technology officer. And you're willing to put them in any one of those 3 roles that are all distinct, separate job descriptions within your hierarchy and legitimately are different positions within your company, then it's arguable that you could submit an application for that employee for each of those different positions under the guise of whichever one gets selected is the position we're going to hire this person into. The government frowns on that, but they have not outright rejected those petitions like that in the past. But it is, in their eyes, a problematic practice. And so unless, again, you can distinctly argue that the positions are within your corporate hierarchy, are separate and distinct positions, are unique positions, they have different qualifications, they have different job duties, they have different salary levels, and so on, then you can argue that they are separate applications and the employee is qualified for each of those positions and you just want him in one of those positions. Let's move on to straight H-1B questions. H-1Bs that are not subject to the cap, or maybe they are, but these fit all general H-1B categories. Oftentimes when we are talking to employers about H-1Bs, the question will come up of, well, don't we have to do recruitment and show we weren't able to find a U.S. worker for this position to sponsor an H-1B? And the answer is no. An H-1B does not require that. That's a green card requirement. And so for the H-1B, all that's required is that you, the employer, require a bachelor's degree in a specific field for that position, and the individual holds a bachelor's degree in that field or a related field, which then makes them qualified for the position. That's all that's required to show. And so the recruitment piece falls out of the question there. So that leads us to the next question, which is, what if the individual does not possess a bachelor's degree in the field related to the position or a bachelor's degree at all? Well, if they don't possess a bachelor's degree at all, then you can look at a variety of things. You can look at a combination of education and experience. Did they go to school? Did they obtain an associate's? Did they go to school for 1 year and then drop out? And then you look at their experience. 4 years of professional experience is equivalent to 1 year of education. So if you've got 12 years of experience, then the individual will be found to have the equivalent of a bachelor's degree in terms of experience. So you can look at their background and say, is there a way between the work experience and if they've done any education, that we can have this background evaluated by a professional evaluator to be the equivalent of a bachelor's degree. And then the second step would be to make sure that it becomes equivalent to a degree in a field related to the position. If you're hiring for an IT director and the person you want to hire has a bachelor's degree in music, that's going to be problematic. The government's going to question as to whether that person's education sets them up to be qualified for the position. However, if they have a bachelor's degree in music, but 20 years of experience in the IT field, then you can take that 20 years of experience, have it equated to a degree in IT, and still push your way into the realm of H-1B world. So you've got to look at the background, and you've got to make sure that the background fits what you're trying to do in terms of hiring the individual. Oftentimes, we've talked a little bit about costs and the fact that H-1B filing fees are over $23.25. You've got legal fees that are in there, costs for other things that are part of it. If you have to get an evaluation, if you have to do other things, the cost of your H-1B can get between $4,000 or $6,000. So there is an investment as an employer in the process. And oftentimes, the question comes up is, well, who's required to pay for the H-1B? The Department of Labor has come out, and because they're part of the H-1B process, it matters, and said that the H-1B is a cost of doing business as an employer, and therefore the employer should bear those costs. In reality, the H-1B has costs that simply cannot be passed on to the employer. Those costs are generally the USCIS filing fees. Those the employer must bear. In terms of the legal fee, we've always recommended, because of the DOL statement, that the employer bear that cost as well. But there is wiggle room in the sense that the DOL has a calculation that if an employee pays the legal fees, their wages are reduced by that amount. So why does that matter? In an H-1B, an employer is required to pay the prevailing wage or the actual wage. If, as an employer, the prevailing wage for a case is $50,000 and you're paying the employee $50,000, and that employee pays the legal fees, which let's say are $2,000, well, the DOL calculation will drop that employee's wages down to $48,000, and now you're not paying that employee the prevailing wage, and your H-1B is in default. And that could subject you to monetary penalties and other penalties that you don't want to be subject to. And so it becomes a tricky calculation. It becomes hard for an employer to maintain, and it becomes hard to look at the second part of that calculation, which is actual wage. If you've got 10 software engineers and all 10 are making $50,000, but only one of them was required to pay for his H-1B, and he's knocked down to 48, he's not now making the actual wage, and so you've got issues with that as well. So the easiest function for an employer is to pay those wages and avoid that calculation. But in so doing, a lot of employers then ask the follow-up question of, well, what if the H-1B employee leaves before his H-1B expires? Can we get reimbursement of those costs? Because that's a big investment. Again, the DOL has come out and said no. But because it's the government and because it's the way things work, they've left wiggle room. They don't let you seek direct reimbursement in the sense of, we paid X number of dollars between filing fees and legal fees and other costs for your H-1B. And so if you leave, employee, you're going to pay us X back. That is against the rules. However, they have allowed for what's called a penalty provision, whereby you can say, employee, you were an investment. We paid fees to bring you on board, to make you an employee of this company. If you leave before your H-1B period ends and you leave within year one, you will pay us $15,000. If you leave within year two, you'll pay us $7,500. And if you leave in the third year of your H-1B, you'll pay us $2,500. That has been okayed because it's not a direct reimbursement and because it's similar to a non-compete type of situation where you're saying to the employee, we value you, we made a contract with you in the sense of we would sponsor you so you would work for us, And in exchange, we want you to pay a penalty if you leave beforehand. The next question that usually comes up is, if your H-1B employee is married or has a significant other, they often want to know, can my significant other work under the H-4, which is the dependent visa to the H-1B? The answer, like all things in law, is it depends. 9 times out of 10, the answer is going to be no. An H-4 by itself does not necessarily allow an individual to work. The one instance in which it does is going to be a limited part of your workforce, and it's going to be for the individual who's gone through a certain stage of the green card process but can't complete the green card process because of priority date issues and other things, and they're kind of in that limbo period. If they're in that limbo period waiting for their green card number to come up so that they can finish the process, at that stage, their spouse or significant other can apply for what's called an H-4 EAD card. But that's a very limited circumstance, and the answer most of the time is going to be no, your spouse won't be eligible to work for quite some time, unless obviously the spouse qualifies independently for their own H-1B or other status. The next question that we're going to address is, when is the employee eligible to work under the H-1B? The answer to that varies. If it's a new H-1B cap situation, obviously if they're selected in the lottery and the case is approved, they're not going to be eligible to work under the H-1B until October 1st. If it's an employee who previously held H-1B status with another employer, or is currently in H-1B status with another employer, and you're filing what's called an H-1B change of employer application, then the rules put forth by the government allow that individual to start working for you upon receipt of your H-1B. So when you file your H-1B for that employee and the government issues its receipt notice, you can put that employee on payroll. You don't have to wait for the approval to come through in order to bring that person on board. So there are instances in which your eligibility to bring an H-1B employee on board are much more flexible than other statuses. And so it does bear in mind that there could be situations in which hiring an H-1B employee is advantageous for you, especially if they're already in H-1B status with somebody else. Let's focus on some of the other non-immigrant statuses. We'll move away from H-1B and we'll just cover all non-immigrant statuses, TN, L1, O1, etc., kind of as a bucket, because a lot of the answers for those will be similar. And a lot of times when companies are sponsoring employees, one of their first questions, because usually the employee is asked the question, is, can we file or do we need to file by premium processing? The government, when you file an application, whether it's an H and TN or O1 or so on, has a standard processing fee. So you pay that application fee and you file the application. Presently, because things are being quite slow, a lot of applications are taking 5 months or more to be adjudicated. So unless you're in a situation where it's a change of employer and the only way the employee can come on board is with an approval notice, and you can wait 5 months for that employee, then chances are the answer to the question is you're going to need premium processing. So what is premium processing? Premium processing is where you pay the government an additional $1,225 filing fee, and that will guarantee an adjudication of that petition within 15 days. Now, an adjudication can mean an approval, it can mean a denial, or it could mean a request for evidence. But at least in some fashion, the government is going to respond to your application, and it's going to be in much less time than 5 months. So if you need an employee quickly, if you need an employee to have an approval notice to put them on payroll, then again, the chances are you're going to have to consider premium processing as part of the overall non-immigrant process. When can an employee start working for me? Unless, again, we're talking about an H-1B change of employer situation, then you're going to have an approval notice, whether they're on a TN, whether they're on an L, an E, an O, whatever other status you have sponsored that individual for, they're going to have some kind of approval in hand before you can complete an I-9 and put them on your payroll. So you have to look at what is the visa status you're sponsoring the individual for, what are the realistic timelines in terms of preparing that petition, what are the realistic timelines in terms of the government sticking to the 15-day processing and issuing an approval versus a request for evidence. And what I mean by that is if you look at the L1 statistics over the last year, 45 to 50% of those get requests for evidence on them issued. So if you're in an L1 situation, you almost have to plan that, okay, we're going to get a request for evidence. That's going to add another 30 days to the process. So you have a timeline in your head. It takes me 3 to 4 weeks to get the application to a place where I'm comfortable and we can file it. It takes the government 2 weeks to issue the request for evidence. It takes the government 30 days to respond after we've submitted our response. So realistically, I feel like I'm going to have this L1 employee in 4 months, 3 months. So you can timeline in your head, when is that employee going to get on staff and be able to start working for you? The other thing that comes up once you've got an application, you've worked through the process, and inevitably it happens at least every other case, I feel like, where we work with a client, they sponsor an employee, the employee's here in the U.S., we file the petition, we've had conversations with the company, we've had conversations with the employee. You know, once we file this is a change of employer, this is a change of status application. Once we file, you got to stay put. Then as soon as we file it, it's, well, we need the employee to go here because they need to meet with a client overseas, or we need the employee to travel for family-based reasons, or whatever the reason is, they've got to travel. How does that impact the filing? Well, if it is a change of status application, the impact can be that the government can say the change of status portion of the application is null and void. The underlying petition itself, the L, the TN, the H, etc., could still be approved, but it just won't be approved as a change of status. Well, what does that mean? If it's approved as a change of status, the approval notice will come through with an I-94 card. That I-94 card will say this employee status is now good until this date, and they can work for this employer, and they are in this status. Well, if the approval notice doesn't have that I-94 card, then what happens is the employee can't come on payroll yet. They've got to first go back out of the U.S. and possibly obtain a visa stamp, come back into the U.S. and get that I-94 card in order for that approval notice to become quote unquote effective. And so this travel issue we try to address with employees and employers prior to filing and make sure that there's no pending travel, but sometimes travel happens, and so we just have to deal with it when it comes. But just know that if it does pop up, it can create issues for that employee and for when they can start and things of that nature. Because of that long window that we talked about in terms of adjudication, where it can be 4, 5, 6 months before you get an answer from the government, the question often comes up, well, we filed the petition, but can't they just come in as a visitor on visa waiver or on a B1 while we're waiting? And in theory, the employee could enter as a visitor. There are activities that are okay, that are acceptable. They could go through orientation. They can look for apartments. They could complete new hire paperwork. They could go through training. They could not, however, enter into the position and just engage in productive employment. That's not acceptable. So when you look at this question and when you look at whether you want to do this, first thing to bear in mind is what are the activities that they can actually do while they're here as a visitor. But the second thing to bear in mind, and probably more importantly, is if they apply to come in as a visitor, the government has access to what's been filed. And if the government does their diligence and sees that you filed a certain type of petition, they're going to ask the employee, why are you coming in? Are you coming in trying to work? And the employee is going to be behind the ball in the sense of the government's going to assume that they're coming in to work. And so they're going to have significant documentation about the orientation, about what their plans are, to overcome that presumption and even be admitted as a visitor. So that's why I said in theory they could, but there are some hoops for them to jump through, and there are things for you as an employer to limit yourself to make sure that you're not abusing the visitor status and making sure that the employee is not conducting productive employment until their visa status is approved and they are in that proper status. The other part of sponsoring an employee that comes up for employers is, well, I've gone through all of this. I've paid the fees. I've worked with the attorney. I've given all this information. I've dealt with the government. Now I finally got the person working here. Can they work for somebody else? Are they just going to turn around and work for somebody else? And the reality is the petition is limited to you as the employer. They are only allowed to work for you as the employer in that position that you sponsored them for in the application. If there are changes to that, whether it be internally for you, you change their job location, you change their duties, or whether that be external, where they change employers, a new application would have to be filed. And in most instances, a new application would have to be approved in order for that individual to actually begin working for anybody else. And so as an employer, you have, I guess, the advantage of having run through the process, having sponsored the individual, of knowing that they are tied to you in that sense. And as long as you're happy and they're happy, this can be a strong, productive relationship for both of you. Well, now you've had the employee been here for a while. They've gone through their first non-immigrant status, and they're getting towards the end of that status, whether it's a year or 3 years or whatever their normal status was for that particular category. And you as the employer wonder, well, what do I need to do? When do I file their extension? For most non-immigrant statuses, you can file your extension 6 months in advance. We try to stay as close with our clients to that 6 months as the client allows, because we know that you have the situation of it's taking the government so long to adjudicate applications. The sooner we file closer to that 6 months, the better chance we have of getting an approval before their existing status expires. Why that's important is mostly for the employee. For the employer, there's a rule in place that says as long as you file your extension before the current status expires, then the employee can work for you for up to 240 days while the extension is pending. So as an employer, as long as you get that extension in, you know that you're going to be able to continue the employee's work authorization. Where the problem lies really is in for situations for the employee. Primary problem that they run into is at the Department of Motor Vehicles. Most non-immigrants are given driver's licenses that expire the same time that their status does. And even though the USCIS has a rule that says an employee who has an extension pending is able to work, most DMVs will not use that same rule in order to extend someone's driver's license. So you might have a situation when you have an employee who's eligible to work and eligible to be here, but can't get a driver's license and can't get to and from work. And so we try to ensure that you don't have that problem as an employer by getting these extensions filed early and avoid the situation of driver's licenses expiring and not being able to be renewed. What is the maximum period of stay for my employee? Every visa category has its own. For an H-1B, it's 6 years. For an L-1B, it's 5. L-1A, it's 7. So when you look at the particular numbers, what I really want you to focus on here is understanding that every non-immigrant status has a maximum period of stay. And as an employer, you need to be cognizant of that maximum period of stay, because once that maximum period of stay hits, unless you've taken steps to get them a different status, to obtain a green card, or employ them outside of the U.S., you're going to be in a situation where you could lose that employee because they don't have any more status within the U.S. and they can't continue to work for you. So as an employer, you need to be aware, again, of that maximum period, and you need to be working with your immigration counsel and saying, when do I need to start the green card process? Do I want to start the green card process? Is it necessary? Those are the questions that are the follow-up to this. But knowing that you have an understanding of that maximum period of stay, knowing that the maximum period means when they hit that period, they're done 90% of the time, then you've got to be aware of it, plan for it, and work with your counsel to make sure that you have taken steps to address that, especially if it's an employee that you really value and want to keep beyond that period of time. Much like the H-1B, oftentimes employees will ask, is my spouse able to work or obtain a social security card so they can get a driver's license or open bank accounts, things of that nature. For most statuses, the answer is no. There are some statuses, the L2 dependent, the E dependent, are statuses where a spouse is able to obtain an EAD card. In those instances, if you're sponsoring an L or an E, then it's worth exploring for your employee, and it's worth knowing that you can indeed the spouse can indeed obtain an EAD card, which will allow them to either work or obtain a social security card so they can open bank accounts and do things of that nature. So really what comes up for us, mostly with our international clients, is they've got an employee overseas who they don't necessarily want to hire, but they do want them to come here for a period of time. When then is the B1, the visitor status as a business visitor, an appropriate visa for your employee? The government has laid out fairly specifically the rules governing when a visitor is a visitor and when they're not. And so where you look to the B1 will be, are they coming in for business meetings? Are they coming in to meet with potential clients or existing clients? Are they coming in to conduct sales meetings? Are they coming in for training, whether it's to give or to receive? Are they coming in for after-service sales on a particular product? Those activities generally are deemed appropriate activities for a B1 individual, and that's when you look to the B1 visa. If the person is coming in, even if it's only for a week, but they're coming in to conduct employment, I mean, they're coming in to be productive. They're going to come in and they're going to work on software for a 1 week stretch, and they're going to do the testing, and they're going to do this, and they're going to do that. Even though it's only a week, that requires a work authorizing status. And even though the temptation for you as an employer might be, hey, let me do the B1 because it's quick, it's easy, person gets in, no one's going to know, no one's the wiser. The reality is you want to stay to the letter of the law. You want to do the right thing because nobody knows until they do know. And then once they know, you've been flagged. you can't use the B1 anymore. You have a harder time getting other statuses, and you're on the radar, and nobody wants to be on the radar. The big issues that come up for employers are often related to visas. Visa is different than status. Status is what the individual has within the U.S. It's what allows them to be here and allows them to work. The visa is simply just the stamp that is in the passport that lets them travel. So oftentimes people will ask, well, especially like, let's go back to the cap. If you get an H-1B cap employee who's outside of the U.S. and you get them approved, they'll ask, well, when can we get a visa for that person and they can come in? Well, the status isn't effective until October 1st. However, the regulations provide that you can obtain your visa and enter the U.S. as early as September 20th. And that would allow the individual to come in, make arrangements in the U.S., get an apartment, open bank accounts, get a driver's license, things of that nature, and then be ready to go on October 1st. They can't start working until October 1st, but in most instances, they can obtain a visa, pardon me, that my Massachusetts came out there. They can obtain a visa beforehand and enter the U.S. before that status kicks in. Does the employee always require a visa, and when do they require a visa? Well, they don't necessarily require one unless they're going to travel internationally. Someone could come in here as an F1 student, and that could be the only visa they ever get. They could change to H1 status, spend 5 years in H1 status, get petitioned for a green card, and get a green card without ever traveling and ever obtaining another visa. The visa, again, is only necessary if the individual is going to travel internationally. It does not provide them status. It just provides them basically a ticket to get back into the U.S. So if you have someone who's going to conduct business travel, or if they're going to travel personally, well, that's when they would require a visa, which generally leads people to ask, oh, well, what's the process for obtaining a visa? What happens is the individual will go online. All of the embassies are now automated in the sense of they want you to complete a visa application form online. You pay the visa application fee, and then you schedule the appointment all online. Once that's all been handled, then the individual will travel to the embassy for that appointment date. They'll carry with them a copy of the petition that's been filed, pay stubs to show that they're still working, perhaps a letter from you to confirm that their employment is still in place. They'll get passport photos. They'll bring their passport, receipt saying that they paid the visa application fee, and they'll show up at the embassy at their appropriate time, go through the visa interview, obtain the visa in their passport, and then return to the U.S. when their trip is over. The documents that they should bring, again, copy of the petition, passport photos, receipt showing that they paid the visa application fee, confirmation that the visa application was completed online, pay stubs, and a letter from the employer confirming current employment. In some instances, some embassies require other documents like bank statements and things of that nature. And in those instances, the employee can check with the embassy to see what the specific requirements are. But generally, that's what they need to require. The other thing that tends to happen, which throws employers off, and employees for that matter, is someone's visa will expire before their approval notice. This can happen for two different reasons. One, if it's a country that the treaty that the U.S. has with that country provides for only a certain duration of visa. Mexico is one of those countries where an L1 is generally good for 3 years on its initial entry, but a visa for Mexico is only good for 1 year. So the employee will have a 3-year approval notice, but only a 1-year visa stamp. And in that instance, the fix is if they need to travel, they just have to apply for a visa on an annual basis using the same approval notice. The other instance where it comes up is if someone's passport will expire before the approval notice. So let's say the approval notice goes through 2019, but their passport expires in 2018. The visa will be cut off when the passport expires. So in that instance, the fix is the employee will have to obtain a new passport sometime in 2018, and when they travel, obtain a new visa in that passport at that time. Let's use our last 10 minutes here to run through quickly some of these green card questions. The green card is the immigrant side of the process. We've been talking about the non-immigrant or temporary statuses. Now we're looking at the permanent statuses. And the biggest question we usually get from employers is, well, when do we start? For the most part, you've got flexibility on that in the sense of, again, employees have a maximum duration of stay, and you can use that to your advantage in the sense of if they've got 6 years on an H-1B status, you can spend 2 or 3 years getting to know the employee and making sure that they're the right fit for you and you're the right fit for them before deciding to go through the green card process, make that investment, and make that process happen. Where you don't have flexibility is if you bring an individual in who's nearing the end of their expiration, who's running out of time, whose maximum period of stay is coming up quickly, then you've got to look at how long does the process take for this individual, and do I have enough time? But the other side is, do they have another non-immigrant status that I can switch them to in case? In an H-1B scenario, the minimum, or the maximum period, now that I'm thinking about it, that you want to wait is at least, you have to file one step of the green card process at least 365 days before they hit their 6-year limit. And the reason that is, if you can meet that date as an employer, then the H-1B max date can be extended annually on a 1-year increment. The other way on an H-1B is if most green cards are a 3-step process, a perm, an I-140, and an adjustment of status. If you get through the perm and I-140 before an individual hits his 6-year limit, then you've also got the ability to extend the H-1B in some instances beyond that 6-year limit. But with the way the perm process is currently running and it taking more than 12 months, the chances of getting that are a little less likely these days. And so you really try to hit filing the perm at least 1 year before they hit their 6-year limit to ensure that you can extend. Now, the other statuses like L and TN and O don't have that same protection. So you need to do a little more planning. If you have an L1B employee who's only here for 5 years and their green card process is going to take 2 years, well, then you want to start the green card process sometime during their 3rd year to make sure you've got time to get them through. So again, this is where knowing about the maximum limits, knowing about the duration that it takes for a green card to happen, and having an open dialogue with your immigration counsel and your in-house team leaders, and having everybody on the same page in terms of planning and strategy is a useful tool and needs to be part of the employee evaluation. When you go through the annual reviews for that employee, part of it should also be, all right, team lead, is it time? Are you ready? Do you want to start this person's green card, so that you can be having that conversation throughout their employment? A lot of times employers will come to us and say, this guy keeps knocking on my door and saying he wants me to sponsor him for EB-2. What is that? The green card processes are, or the green card process for employment-based is divided into 5 employment-based categories. EB-1 is for extraordinary ability multinational manager folks. EB-2 is for folks with a bachelor's degree and 5 years of experience or a master's degree. EB-3 is bachelor degree positions, and so on. Most employees are asking about EB-2 if they are from India or China, because for those countries, the priority dates are backlogged and there's a significant weight in the EB3 and the EB2 category, but it's less in the EB2 category. And so they're concerned with the wait period. If they're in an EB3 category, it might take them 7 years to get a green card, but if they're in EB2, it might only take them 3. And so that is why they come to you with that question. So what does it mean to you as an employer? Well, as an employer, you've got to be cognizant of the fact that really what governs the process for you is what is the position I am offering the employee require for entry into that position. If that position you're offering requires a master's degree or a bachelor's degree and 5 years of experience, then you can sponsor that person for EB2. But if the position you have and you're offering that employee is a bachelor's degree and 3 years of experience, it doesn't matter if the employee has a PhD. The position requires a bachelor's degree in 3 years, so it's going to be EB3 sponsorship. And so you have to understand as an employer how that impacts the employee and whether as an employer you have flexibility. Is there a position that you can see this employee in 2 years from now that would require a master's degree? And do you want to do the green card for that position to help the employee out? That's really where it comes in as an employer. Can we premium process the green card? The perm process is not available for premium processing. The DOL does not allow that. You file it and you wait. When you get to the I-140 stage, in most instances, you can premium process. The question is, will it pose any advantage? Generally for us, where we do it is when, if we file the premium processing on the I-140 and that approval will allow us to extend someone's H-1B beyond 6 years, that's generally the only time that we will do premium processing on the I-140. We talked about the fact that there are several green card categories. So oftentimes employers ask, well, am I limited to only one? And the answer is no. If an employee qualifies for an EB1 and an EB2, then you can certainly do both. The question really comes down to cost. There's going to be legal fees, there's going to be government fees, there's going to be, in the perm instance, there's going to be recruitment fees. And so you have to look at the cost and weigh that against the options for the employee and you as an employer and what you're doing to help them out, and decide whether it makes sense for you from a business perspective to do that. Then the big question that always comes up is if they leave during the green card process, what happens? There's only one instance in which an employee can take the green card with them, so to speak. Well, two instances. One is when it's already been approved, but the other is if they've got, it's a 3-step process, perm, I-140, 45. If their I-140 has been approved and their I-45 has been pending for at least 180 days, then the individual can take the green card. The green card is portable to a new employer. Anytime before that, if you're in the perm stage, if you're in the I-140 stage, if they haven't filed the adjustment of status, anytime they leave before that and the employee doesn't take the process with them, they simply lose the process. And so once you've engaged in the green card process, chances are the employee is going to ride that process out with you because it's to their benefit to do that. And so bearing that in mind is helpful in helping you plan and make those decisions about whether you should and when you should do the green card process. The perm process for most employees is the first step in the green card process. It is normally required for all EB3s and for most EB2 petitions. Most of your employees, if they're TN, E3, L1B, H1B, are going to have to go through the perm process. So most of the times as an employer, you're going to be required to do the perm process for an individual to start the green card. The perm process is governed by the Department of Labor, and what it is basically the government requires you as an employer to recruit for that position, show that you were unable to find qualified U.S. workers in order to get permission to sponsor the non-U.S. citizen foreign national in the position. Much like most things that we've talked about today, the second question the employer usually asks us is, well, who's required to pay for this? Again, this portion of the process is governed by the DOL. Like the H-1B, the DOL has come out and said this is a cost of doing business, and that cost of doing business must be borne by the employer. We talked about the perm process being recruitment-based, which usually throws employers off because they say, well, I've already got somebody in the position. Why do I have to recruit? And the answer is, well, because the Department of Labor makes us. They want definitive proof that you have gone through a rigorous recruitment process and were unable to find U.S. workers. So they make you run newspaper ads, an online ad, state job bank ads, and other various ads to demonstrate that you've done the recruitment that they want you to do. Generally, on terms of timelines for the perm process, the recruitment is conducted over a 30-day period. There's a 30-day quiet period. If no resumes from qualified applicants is received during that 60 days, then you're eligible to file the perm. Once you file, it's currently taking about 8 to 10 months for that perm to be adjudicated by the DOL. So overall, you're looking at anywhere from 10 to 12 months just for the perm process. Should you as an employer treat perm recruitment differently than normal recruitment? The DOL says no. They would like it to be similar to your normal recruitment. The reality is it's just not. It looks different. It smells different. It tastes different. It's just simply different. I mean, when you normally recruit, the whole point of recruitment is to reach the largest audience possible. When you do perm recruitment, you're running newspaper ads, you're running state job bank ads, you're placing ads in places you don't normally place, and you're not getting the same pool. So it ends up being different. The other thing is with perm recruitment, you're on a very tight deadline in terms of if resumes come in, you have to respond within a reasonable time frame in order to not cool the market. So you've got to be very diligent about when resumes come in, about reviewing those resumes, about contacting potential candidates. If you receive a resume from a qualified candidate, unless that candidate can be disqualified for lawful job-related reasons, they wouldn't accept the salary. They wanted, relocation expenses, or they got a bad review from their prior employer, or they didn't pass a drug test, something like that. Unless there's a lawful job-related reason and they are qualified, meaning they meet the minimum education and experience for the position, you have to shut down the perm process. The perm process is based under the notion that you can tell the Department of Labor that you received no qualified applicants. If you did, you can't tell the DOL that. You can't go through the process. The only instance in which you could is if you had multiple positions open and you had 3 IT people you needed and you got 1 candidate, you could still sponsor 2 people for the perm process through that. And no, the employee who you've already got, that is your foreign national, does not need to reapply for the position, does not need to be reevaluated. They can simply be considered in the position and under the guise of the process covered. We've gone over our time, and for that I apologize, but I appreciate you hanging with me, listening to today's webinar. It was a lot of information. We covered a lot of different topics. I didn't get to all of your questions, but hopefully I got to a multitude of them. But if you have questions that weren't answered today, please email me at russell@fordmurraylaw.com or my partner Michael at fordmurraylaw.com. We'll be happy to answer those questions that you have. Again, thank you for attending. We appreciate it, and have a great day.